Okay, let's start the class immediately. We won't waste any time. I wish I can complete a few orders today. Till 21, we have done, right? Uh, in 21, I will make you mark the important rules at the end. Right now, just let's come to order number 22. So, order number 22 talks about death, marriage, and insolvency of parties. Okay, so what happens, right? Ki creation, assignment, devolution of interest during pendency of suits. What happens? So, आपको order number 22 से related ये चीजें आप दो तीन लिख लीजिएगा. First point is creation, assignment, devolution of interests during pendency of suits. Secondly, does it apply to appeals? Yes, it applies to suits as well as to appeals, right? Thirdly, it does not apply to execution proceedings or to writs. And this is an exhaustive order. Okay, ये एक judgment में कहा गया था. And lastly, order number 22 is procedural in nature and it is not penal in nature. इसमें तीन चीजें कवर की गई है, डेथ, मैरिज एंड इंसॉल्वेंसी. रूल नंबर 1 से लेके 6, 9 और 10 ए है डेथ से रिलेटेड, 7 इज मैरिज एंड इंसॉल्वेंसी इज रूल नंबर 8. राइट? No suit can be passed against a dead person. अगर no suit against a dead person is possible, I mean, sorry. And if a decree is passed, it's a nullity. And if the plaintiff claims that he did not know of the death, the court may bring the LR of the defendant on record. Thereby, the suit shall be instituted on the day the plaint was presented. Right? So, what are the effects on the suit? That is what it is talking. Means what is the effect of death? What is the effect of marriage? What is the effect of insolvency of the parties? Firstly, no abatement by parties' death if right to sue survives. The death of the plaintiff or the defendant shall not cause the suit to abate if the right to sue survives. If the right to sue survives, the suit will not end. It will continue. Right? Procedure when one of the several plaintiff or defendant dies and right to sue survives. Right? So if there are number of plaintiffs, what happens? Right? If one of them dies, so what happens with the other? Entry to that effect will be made on record, right? And it will continue against those surviving ones. Procedure in case of death of one of several plaintiffs or sole plaintiff. So where one or two or more plaintiff dies and right to sue does not survive to the surviving plaintiff or plaintiffs alone, or sole plaintiff or sole surviving plaintiff dies and right to sue survives, the court on application made in that behalf shall cause the LR of the deceased plaintiff to be made party and shall proceed with the suit. Okay. Remember this with respect to this. Procedure in case of death of one of several defendant or of sole defendant. Just go through it once. इसमें इतना कुछ है नहीं है, right? Come to rule number 7. Suit not abated by marriage of the female party. It can directly come in the prelim like that way only. That does the suit abate on the marriage of the female party? The marriage of a female plaintiff or defendant shall not cause the suit to abate, but the suit may notwithstanding be proceeded with to judgment, and where the decree is against the female defendant, it may be executed against her only alone. Where the husband is by law liable for the deaths of the wife, the decree may, with the permission of the court, be executed against the husband also. And in case of judgment for the wife, the execution of the decree may, with such permission, be issued upon the application of the husband, where the husband is by law entitled to the subject matter of the decree. Insolvency rule number 8. When plaintiff's insolvency bars the suit, the insolvency of a plaintiff in any suit which the assignee or receiver might maintain for benefit of his creditors shall not cause the suit to abate, unless the assignee or the receiver declines to continue the suit, or unless for any other special reason the court otherwise directs to give security for the cause thereof within such time as the court may direct. What is the effect of abatement or dismissal? Where a suit abates or is dismissed under this order, no fresh suit shall be brought on the same cause of action. You have to read this with section number 12. The plaintiff or the person claiming to be the LR of the deceased plaintiff or the assignee or the receiver in case of a Insolvent plaintiff may apply for the order to set aside the abatement or dismissal, and if it is proved that he was being prevented by any sufficient cause from continuing the suit, the court shall set aside the abatement or dismissal upon such terms of cost as otherwise it thinks fit. The provisions of section number 5 of limitation act will also apply, right? Delay condon वाला इस पे applicable होगा. देखो यहाँ पे लिखा हुआ एप्लीकेशन ऑफ ऑर्डर टू प्रोसीडिंग, डज इट अप्लाई टू एग्जीक्यूशन? नथिंग अप्लाइज. Now, order number 23, it has been asked this time a lot in mains, right? What does, they just ask directly, what does order number 23 say? So it's very simple, to the point. Order number 23 talks about withdrawal of suits and adjustment of suits, right? So firstly, withdrawal of suits or abandonment of a part of claim. Every sub rule is important in this rule number 1. Okay, so withdrawal of suit or abandonment of a part of claim, sub rule 1. At any time after institution of the suit, the plaintiff may, as against all or any of the defendants, abandon a suit or abandon a part of his claim, whole or part. Anything is possible. Totally he can abandon the suit, or he can abandon certain part of his claim. Proviso that where the plaintiff is a minor or other person to whom the provisions contained in Rule 1 to 14 of Order number 32 extend, neither the suit nor any part of the claim shall be abandoned without the leave of the court, right? With respect to minors, that Order number 32 is with respect to minors, right, or unsound persons. तो अगर तुम माइनर या अनसाउंड पर्सन के अगेंस्ट अबेंडन करना चाहते हो तो यू विल हैव टू टेक द लीव ऑफ द कोर्ट. An application for leave under the proviso to sub rule 1 shall be accompanied by an affidavit of the next friend, and also if the minor or such other person is represented by the pleader, then by the certificate of the pleader to the effect that the abandonment is proposed is in his opinion for the benefit of the minor or such other person, कि हमने भाई benefit के लिए ही करा हुआ है, या एफिडेविट या एक सर्टिफिकेट होना चाहिए. फिर रूल सब रूल 3 टॉक्स अबाउट विड्रॉवल. ओके, sub rule 1 and sub rule 2 spoke about abandonment. Now sub rule 3 is talking about withdrawal, where the court is satisfied that the suit must fail by reason of some formal defect, okay, or that there are sufficient grounds for allowing the plaintiff to institute a fresh suit for the subject matter of a suit or a part of claim. तो कोर्ट का satisfaction है. Supposing it may, on such terms as it thinks fit, grant the permission to the plaintiff to withdraw from the suit or such part of claim with liberty to institute a fresh suit in respect of the subject matter of such suit or such part of the claim. Okay. Now sub rule 4, where the plaintiff abandons any part any part of the claim or the suit under sub rule 1, or withdraws from a suit or part of the claim without permission referred to in sub rule 3. बिकॉज सब रूल 3 में ऐसे उन्होंने बोला है कि अगर कोर्ट का सेटिस्फेक्शन हुआ है और आपको कोर्ट ने परमिशन दी है, लेकिन आपने ये चीज करी है विदाउट द परमिशन ऑफ द कोर्ट, he shall be liable for such costs as the court may award and shall be precluded from instituting any fresh suit in respect of any such subject matter or any part of the claim. Nothing in this rule shall be deemed to authorize the court to permit one of several plaintiffs to abandon a suit or part of the claim under sub rule 1 or to withdraw under sub rule 3 any suit or part of claim without obviously the consent of the other plaintiffs, right? So there is one thing they are talking about, withdrawal without leave and withdrawal with leave. So if you do it without leave, then you will be precluded. It's a very simple rule. Logical तरीके से आप पढ़ोगे ऑटोमेटिकली आपके दिमाग में बैठ जाएगा. रूल 1A, व्हेन ट्रांसपोजिशन ऑफ डिफेंडेंट एज प्लेंटिफ मे बी परमिटेड, यानी कि डिफेंडेंट टू प्लेंटिफ, where a suit is withdrawn or abandoned by a plaintiff under rule 1 and a defendant applies to be transposed as a plaintiff under rule 10 of order 1, the court shall, in considering such application, have due regard to the question whether the application has a substantial question to be decided as against any of the other defendant. Obviously the court will allow, but it will see the other things into consideration. Limitation law not affected by the fresh suit. In any fresh suit instituted on permission granted under the last preceding rule, the plaintiff shall be obviously bound by the law of limitation in the same manner as if the first suit had not been instituted. ऐसा ही माना जाएगा. Limitation law applicable है. Rule 3, very important, it talks about compromise of suits, right? Where it is provided to the satisfaction of the court that a suit has been adjustment ho chuka hai wholly or in part by any lawful agreement or compromise in writing and signed by the parties, or where the defendant satisfy the plaintiff in respect of the whole or any part of the subject matter of the suit, the court shall order such agreement, compromise, or satisfaction to be recorded, and shall pass a decree in accordance with that, so far as it relates to the parties to the suit, whether or not the subject matter of the agreement, compromise, or satisfaction is the same as the subject matter of the suit. Proviso, that where it is alleged by one party and denied by the other that an adjustment or satisfaction has been arrived at, the court shall decide the question, but no adjournment shall be granted for the purpose of deciding the question unless the court, for reasons to be recorded, thinks it fit to grant such adjustment. An agreement or compromise which is void or voidable under the Indian Contract Act shall not be deemed to be lawful within the meaning of this rule. You must know that, right? Means अगर court satisfaction या lawful है then only compromise हो सकता है. So remember this. Compromise of suit is under Order 23, Rule 3. Remember that. Bar to suit, right? No suit shall lie to set aside a decree on the ground of compromise on which the decree is based was not lawful, right? No suit to set aside the compromise decree, ये वो बताना चाहते, consent decree, right? Rule number 3B, no agreement or compromise to be entered in a representative suit without the leave of the court. अगर representative suit है, so can there be a agreement decree or a compromise decree? Is it possible? So no agreement or compromise in a representative suit shall be entered without the leave of the court expressly recorded in the proceeding, and such agreement or compromise entered into without the leave will be void. Shall be void लिखा है. Okay, before granting the leave, the court shall give notice in such manner as it thinks fit to such person as may appear to be interested in the suit. Execution proceedings पे ये applicable नहीं है. Representative suits कौन से है under section number 91, 92, order 1, rule 8. फिर Hindu family, undivided Hindu family में, right? A suit in which the manager यानी जो कर्ता होता है of the undivided Hindu family sues or is sued as representing the other members of the family. Yeah, any other suit in which the decree passed may by virtue of the provisions of this code or any other law for the time being in force binds any person who is not named as a party to the suit. Okay. Abhi, who does the payment into the court? The defendant will do. That is order number 24 talks about that, right? A deposit by defendant of amount in satisfaction of the claim, right? So he has to make a payment into the court. That is order number 24. Then plaintiff has to give security for the cost. That is order number 25. Just know the orders, right? Order number 24 talks about payment, that is by the defendant. Order number 25 talks about security for the cost. Who will pay the security for the cost is plaintiff. Now order number 26, hum isme I'm not going to go into detail because this is like I already had told you, orders and their rules are with respect to the procedures, and sections are substantive law. So now हमने already 75 to 78 commissions पढ़े थे, right? So a direct question can come that commission falls under which order. So that is order number 26. So just in this, see rule number 1, cases in which court may issue commission to examine witnesses, right? Any court may in any suit issue a commission for examination on interrogatories or otherwise of any person resident within the local limits of a jurisdiction who is exempted under this code from attending the court, or who is sick or who is infirm. So तीन type, exempted person, sick है या infirm है, तो उनको interrogatories के basis पे आप examine कर सकते हो. I even told you that is the discretionary power of the court में है इसमें कि court issue कर सकती है commission, and it can be suo moto or on the application by the parties. अभी देखो इसमें एक कौन से चीज़ों के लिए कमीशंस इश्यू किए जाते हैं, इसके जो आइटैलिक्स में दिए हैं, कमीशन टू एग्जामिन विटनेसेस, दैट इज नंबर 1. देन गो टू नंबर 2. Number 2 was commission for local investigation. Then number 3 is commission for scientific investigation, performance of a ministerial act and sale of a movable property. Then commission for examining accounts. Then commission to make the partition of the properties. Then ये general provisions है, right? इसमें आपको power of the commission's commissioner बताया है. Okay, he can examine the parties themselves and any witnesses. He can call for any documents. He can enter upon any land or building और वहां पे जो चीजें उसको फाइंड आउट करनी है वो सब कर सकता है. रिमेंबर रूल नंबर 16. ओके, क्या क्या पावर्स होते हैं कमिश्नर के वो आपको पता होना चाहिए. एक्सपेंसेस दे हैव टू ऑब्वियसली बी पेड इनटू द कोर्ट, जो पार्टी चाहती है कि कमीशन इशू हो वो. ओके, फॉरेन के भी कमीशन होते हैं, राइट? कमीशन फॉर फॉरेन ट्रिब्यूनल्स, दैट इज फ्रॉम रूल नंबर 19 टू रूल नंबर 22. जस्ट रिमेंबर दैट. अच्छा, रिपोर्ट ऑफ द कमिश्नर जो होता है it is a prima facie evidence, but it is totally upon the court as to what weightage it has to give upon it and how much of it to be used as an evidence. Okay, now ये जो बेसिकली आपको पता होना चाहिए कौन से ऑर्डर में फॉल होता है. ये सारे जो है ऑर्डर नंबर 22, ओके, डेथ, मैरिज, इंसॉल्वेंसी, देन ऑर्डर नंबर 26, आपको ये सब थोड़े ऑर्डर्स बाय हार्ट होने चाहिए. ओके, ऑर्डर नंबर 27, अब ये देखिए ऑर्डर नंबर 27, फिर ऑर्डर नंबर 27A. आप अपने इंडेक्स में देखना चाहते हो आप वहां पे देख सकते हो. आई एम सीइंग फ्रॉम विद इन द टेक्स्ट. देन ऑर्डर नंबर 28, ऑर्डर नंबर 29, देन ऑर्डर नंबर 30, ऑर्डर नंबर 31. ओके, ये आप सिर्फ हेडिंग्स पढ़ लीजिएगा. अच्छा, हमने सेक्शन नंबर 79 पढ़ा था, उसी के साथ आपको ऑर्डर नंबर 27 पढ़ना है. सूट बाय और अगेंस्ट द गवर्नमेंट और पब्लिक ऑफिसर्स इन देयर ऑफिशियल कैपेसिटी. हमने सेक्शन नंबर 79 पढ़ा था, 78 79. तो आपको पता होना चाहिए कि किस तरीके से गवर्नमेंट या पब्लिक ऑफिसर्स के अगेंस्ट वो कैसे सूट हम उनके अगेंस्ट फाइल कर सकते हैं या वो कैसे फाइल कर सकते हैं. दैट इज ऑर्डर नंबर 27. ओके, then order number 27A talks about suits involving a substantial question of law as to the interpretation of the constitution or as to the validity of any statutory instrument. So there are two things. If you want a certain kind of interpretation of the constitution या कोई statute है उसकी validity जानना चाहते हो तो ये इसमें किसको हम notice भेजेंगे ये वगैरह है. So notice to the attorney general or the advocate general, right? Any suit where it appears to the court, right, that any question as is referred to in Article 30 to Article 47 is involved, the court shall not proceed to determine until a notice has been given to the Attorney General if the question of law concerns the central government and Advocate General if the law concerns the state government. So notice आपको भेजना जरूरी होगी before adding the government as a party. You cannot just proceed like that way, right? Because they are at a rank, they are at a dignitary position. So order number 27A talks about किसको हम notice भेजेंगे, तो Advocate General नहीं तो Attorney General को, right? अगर statutory instrument है, as if you want to find out the validity of any statutory instrument, then obviously again you cannot proceed unless and until you give a notice to the government pleader if the question involves the government, and to the authority which issued the statutory instrument if it concerns the authority other than the government, right? So just know this rule 1, rule 2, order number 27A talks about that. See, these few orders from order number 27 to order number 31, just know the headings, right? What are those orders talking about? Then order number 28 talks about suits by or against military persons या naval men या airmen जो military में लोग होते हैं. अगर उनको आप उनके against आप suit करना चाहते हो तो किसको आप भेजोगे? एक आपको उनको notice तो भेजना पड़ेगा ना, right? कि हमने आपके against किया है. That is what they are saying over here. वो अपना pleader appoint कर सकते हैं. That is order number 28. Then corporates होते हैं जो, right? Suits by or against corporations जो होती है, right? तो ये उसको लेके है order number 29. 30 talks about suits by or against firms and persons carrying on business in names other than their own, right? So that is it. And order number 31 talks about suits by or against trustees hai, executors hai, administrators hai. They are kind of representatives, right? So that is order number 31. Order number 32 talks about suit by or against minors and persons of unsound mind, right? So minor to sue by next friend, right? Every suit in a minor shall be instituted in the name by a person who in such suit shall be called the next friend of the minor. Again, if the plaintiff.
मैम आप म्यूट हो गए.
Sorry. Suits by or against minors and persons of unsound mind. So there can be a plaintiff minor or a defendant minor, or there can be a person who is unsound mind, means who can be a plaintiff or a defendant. तो उनको कौन represent करता है? So minor, if he is suing, means he is a plaintiff, instituting a suit, then he will, if he is a minor, then he will do it by a next friend, right? Then where a suit instituted without next friend, plain to be taken off the file, so it will be taken off the file, right? See, where a suit is instituted by or on behalf of minor without next friend, the defendant may apply to have the plain taken off without with cost to be paid by the pleader or the person by whom it was being presented. The cost obviously bharna padega. So for the plaintiff it is next friend, and for the defendant we will use the word who represents the minor. If he is a defendant, then it is a guardian, right? So where the defendant is a minor, rule number 3, please see that the court, on being satisfied of the fact that he is minor, shall appoint a proper person to be a guardian for the suit of the minor, right? So an order for appointment of the guardian for the suit may be obtained upon application in the name on behalf of the minor or by the plaintiff. Such application shall be supported by an affidavit verifying the fact that the proposed guardian has no interest in the matters in controversy in the suit which is adverse to that of the minor, and that he is a fit person to be so appointed. Obviously, if he's a guardian, or if he is a next friend, that person has to be a fit person. A decree against minor not to be set aside unless prejudice has been caused to his interest, right? Now who may act as a next friend or to be appointed as a guardian for the suit? So just note down, he must be of a sound mind, he must have been attained majority, his interest is not adverse, right? And consent of the guardian to be acquired. These are the 4 things, just know that. Just keep this in mind. Rule number 4, who may act as a next friend or who can be appointed as a guardian for the suit. So देखो वहां पे ही लिखा, who is a sound mind, who has attained majority, that the interest of a such person is not adverse to that of the minor, and that he is in not any case the next friend, a defendant, or in the case of a guardian for such plaintiff, right? Know this at least. ये एक ऑर्डर में एक और चीज बताया जा रहा है कि द प्लेंटिफ और द डिफेंड हु इज अ माइनर, if he becomes a major, then what happens, right? So what are the options available with him, right? Where minor co-plaintiff attains majority, desires to repudiate the suit, right? Course to be followed by a minor plaintiff on or applicant on attaining majority. क्या वो कर सकता है, right? Means he has a power to elect. मीन्स क्या वो डिसमिस करना चाहता है जो भी सूट पेंडिंग है, क्या वो अबैंडन करना चाहता है, राइट? सो दिस इज व्हाट इट इज सेइंग. Means the minor person has the opportunity to choose. That is what they are saying. अच्छा, सी रूल नंबर 11, रिटायरमेंट, रिमूवल और डेथ ऑफ अ गार्जियन फॉर द सूट. क्या होगा? ऑब्वियसली अगर ऐसा कुछ हो गया है, या सेम थिंग हैपेंस विद द नेक्स्ट फ्रेंड हु इज रिप्रेजेंटेटेड द माइनर प्लेंटिफ, तो आपके पास क्या ऑप्शन होती है? कोर्ट हैज द मींस द कोर्ट हैज टू यूज इट्स पावर एंड अपॉइंट अ न्यू गार्जियन in that case, if there is a retirement, removal or death of the guardian for the suit. See, if you go to see from this order also, direct questions have been asked. Like order number 32 talks about what? It talks about suits by minors or unsound mind. I told you all, if the minor is a plaintiff, then the person who representative, that person is titled as next friend, and for the defendant we'll call him a guardian, right? Now what they are saying, this entire order equally applies to persons who are of unsound mind also. That's what judge is saying. Now coming to 32A, suits relating to the matters which concern the family. फैमिली सूट, फैमिली मैटर्स जो होते हैं, राइट? सो एप्लीकेशन ऑफ द ऑर्डर, ये कौन से एप्लीकेशन प्रोसीडिंग्स पे अप्लाई करते हैं? दे आर ऑल रिटन फ्रॉम ए टू जी. सूट फॉर प्रोसीडिंग फॉर मेंटेनेंस, वैलिडिटी और इफेक्ट ऑफ एन एडॉप्शन, राइट, इंटेस्टेसी, विल, सक्सेशन, ये सारे मैटर्स को लेके एप्लीकेबल है. मैट्रिमोनियल रिलीफ, मैट्रिमोनियल स्टेटस डिसाइड करना, लेजिटिमेसी ऑफ अ पर्सन, this all it is applicable, right? They will be obviously held in camera. Duty of the court to make efforts for settlement, obviously, right? So that there is no dispute. That's what they are talking about. Duty to inquire into the facts. It is the court's duty that they must inquire into the fact which are being alleged by the plaintiff or by the defendant. Know what is the meaning of the family over here under rule number 6, right? Suits by indigent person, order number 33. जैसे अपील्स बाय इंडिजेंट पर्सन मैंने आपको बोला था 33 44 साथ साथ पढ़ना है. अभी इंडिजेंट पर्सन कौन, मीन्स हम जो कहते हैं गरीब इंसान, उसके लिए है. सूट में बी इंस्टीट्यूटेड बाय एन इंडिजेंट पर्सन, राइट? सो सब्जेक्ट टू फॉलोइंग प्रोविजन, सूट में बी इंस्टीट्यूटेड. तो कौन, किसको हम इंडिजेंट पर्सन कहते हैं? दैट इज एक्सप्लेन अंडर एक्सप्लेनेशन ए एंड बी. So a person is an indigent person if he is not possessed of sufficient means other than the property which is exempted from attachment in execution of the decree and subject matter of the suit. याद रखो इसमें सेक्शन नंबर 60 ये जो ब्रैकेट में लिखा है, right? So if he is not possessed of sufficient means to enable him to pay the fee which is prescribed by law for the plaintiff in such suit, means उसके पास पैसे नहीं है plaintiff के पैसे भरने के लिए, right, to institute a suit. And secondly, or where no such fee is prescribed, if he is not entitled to a property worth 1000 rupees other than the property which is exempted from attachment in execution of a decree and subject matter of the suit, other than that, means section number 60, तो उसको हम कहेंगे indigent person. Explanation 2, any property which is acquired by a person after the presentation of the application for permission to sue as an indigent person and before the decision of the application shall be taken into account in considering the question whether or not that person is indigent. Okay. And explanation 3, where the plaintiff sues in the representative capacity, the question whether he is an indigent person shall be determined with reference to the means possessed by him in such a capacity, right? Remember this rule, very important. Rule number 1 under order number 33, which is talking about suits by indigent person. देखो हमने ये जो करे from order number 20, ऑर्डर नंबर 27 से लेके जो है ना, they are giving specific kind of suits by government, suit by public officers, by military persons and representatives, that is like executors वगैरह. So this is talking about specific persons who how the suits will be instituted by them. So this order number 33 is suits by indigent person, right? Please know कि रूल नंबर 1 टॉक्स अबाउट किसको हम इंडिजेंट पर्सन कहेंगे वगैरह. इंक्वायरी भी करी जाती है कि वो इंडिजेंट पर्सन है कि नहीं है. दैट इज रूल नंबर 1A. एप्लीकेशन में क्या क्या डालोगे आप जब इंडिजेंट पर्सन की तरह सू करना चाहते हो, राइट? जस्ट दिस इज इट विथ रिस्पेक्ट टू इट. देखो प्लीज सी ऑर्डर नंबर 34. या दीज ऑल रोमन. कभी कभी रोमन्स में रोमन नंबर्स में कॉम्प्लिकेशंस होती है, तो अगर आपको ऐसी कॉम्प्लिकेशन होती है तो आप ऊपर लिख लीजिएगा. अगर मॉर्गेजेस इमूवेबल प्रॉपर्टी से रिलेटेड मॉर्गेजेस के जो सूट्स होते हैं, राइट, तो उसके लिए भी पार्टीज टू सू, व्हाट ऑल दे कैन सू फॉर, फोरक्लोजर, सेल, रिडेम्पशन, ये सब चीज़ों के लिए हम सू कर सकते हैं. नेवर हैज़ बीन आस्क्ड, जस्ट नो दैट देयर इज अ ऑर्डर विथ रिस्पेक्ट टू इमूवेबल प्रॉपर्टी मॉर्गेजेस को लेके भी सूट फाइल किया जा सकता है. इंटरप्लीडर हमने सेक्शन भी पढ़ा था. दिस कम्स इन डायरेक्ट मेंस क्वेश्चन आल्सो, राइट? राइट अ नोट ऑन इंटरप्लीडर and in prelim directly it can come. right? Plaint and interpleader suit. In every suit of interpleader, the plaint shall, in addition to other statements which are necessary for plaint, क्या क्या state करना चाहिए, plaint के अंदर क्या क्या लिखा हुआ आना चाहिए, plaintiff, that the plaintiff claims no interest in the subject matter other than the charges or the cause, then that the claim made by the defend, that there are the claims which are made by the defendant severally, and that there is no collusion between the plaintiff and any of the defendants. जो भी payment of thing होती है claimed into the court, where the thing claimed is capable of being paid into the court or placed into the custody of the court may be the plaintiff may be required to pay or place it before the court, so that he can be entitled to any order in the suit. Procedure where the defendant is suing the plaintiff. Where any of the defendants in an interpleader suit is actually suing the plaintiff in respect of the subject matter of the suit. The court in which the suit against the plaintiff is pending shall, on being informed by the court in which the interpleader suit has been instituted, stay the proceedings. तो वहां पे आप स्टे करवा दोगे. मैंने आपको जब हमने सेक्शन पढ़ा था तो हमने ये भी पढ़ा था कि एक तो इंटरप्लीडर सूट फाइल कर सकता है वो प्लेंटिफ, राइट? बट इज देयर अ पॉसिबिलिटी ऑफ अ सूट आल्सो एट द सेम टाइम? यस, देयर इज अ पॉसिबिलिटी. तो ये उसी में, ये जो रूल है ये वही कह रहा है. तो क्या करा जाएगा? ऑन बीइंग इन्फॉर्म बाय द कोर्ट इन विच द इंटरप्लीडर सूट हैज बीन इंस्टीट्यूटेड, राइट? जो अगर वो डिफेंडेंट ने प्लेंटिफ के अगेंस्ट सूट भी फाइल किया है तो वो स्टे करी जाएगी. दैट इज व्हाट दे आर सेइंग, राइट? देन स्पेशल केस सूट्स, राइट? ऑर्डर नंबर 36, राइट? यहाँ पे सेक्शन नंबर 90 आप लिख दीजिएगा. पावर टू स्टेट द केस फॉर कोर्ट्स ओपिनियन. तो आप वहाँ पे पार्टीज क्लेमिंग to be interested in the decision of any question of fact of law may enter into an agreement in writing stating such question in the form of case for opinion of the court, and providing that upon finding of the court with respect to such question, कौन सी चीजों के लिए opinion of the court आप मांग रहे हो. That's what they're saying. One is sum of money, प्रॉपर्टी एंड वन और मोर पार्टीज टू रिफ्रेन. हमने बोला था जब हम जब वो पढ़ रहे थे सेक्शन, तो एक मनी से रिलेटेड, एक प्रॉपर्टी और एक एक्ट. तो आप ओपिनियन ऑफ द कोर्ट लेना चाहते हो, बट एज पार्टीज यू ऑल हैव टू अग्री, देन यू ऑल विल स्टेट इट फॉर द ओपिनियन ऑफ द कोर्ट. See, where value of the subject matter must be stated, agreement to be filled and registered as a suit ही किया जाएगा. Parties to be subject, obviously they have to be under the court's jurisdiction जहाँ पे वो अपने opinions in the form of agreement दे रहे हैं. Hearing and disposal of the case, no appeal from a decree passed. Remember this rule 6, no appeal from a decree passed under rule 5. अगर जो भी agreement होता है, means remember one thing, जो agreement होती है between parties, it converts into a suit, then नॉर्मल तरीके से सूट तरीके से ही इसको ऑर्डिनरी सूट की तरह ही चलाया जाएगा. पर इसमें जो भी जजमेंट या डिक्री फॉलो करती है उसके बाद, राइट, it's a compromise decree. We know that because obviously you have stated it in the form of an agreement for the opinion of the court. So no appeal shall lie from a decree which is passed under rule number 5. Anyways, I'll see you all tomorrow again at 11 o'clock only. We'll stop the class here. Okay?